Hear ye. All persons having business before this court will draw near, give their attention, and they shall be heard.
Good morning. Please have a seat. Well, welcome to the Appellate Division 4th Department. A few reminders. The panel is very familiar with the records and briefs. We do not need a recitation of the facts unless you're asked. And you all have contentions in your brief, and we would ask that you get right to them and just focus on the key ones. And don't forget, too, that we don't allow rebuttal, but you can make an application after oral argument for to apply for leave to file a post-argument submission. We're not recommending that if you don't have to, but it's certainly available. In any event, the first case for argument is number 462, People versus Wright. Counselor, good morning.
Good morning. May it please the court, Nicholas Stefanzo for Lafayette Wright. Mr. Wright was in a level 3 stop from the moment he encountered Officer Brown.
And how do you get there?
Right.
How do you consider that a level 3?
Well, the test for whether a defendant is in a level 3 stop is to considering the totality of the circumstances and ask whether a reasonable person in the defendant's position would have believed that their freedom was significantly limited. Right. And
So
it's our contention.
Yeah. I want you to correct me if I'm wrong.
Sure.
Okay. All right. So my recollection is that the police see him, he matches the description, and they put the light on. Okay, they put their police lights on. And that's all they did. And then he bolts.
Oh, I would dispute that. I think he shouted stop first, and then Mr. Wright fled. I think that's
Okay, so
that's on video.
The shout raises it from a stop and ask to a level 3.
Yes, it really does. If you watch the video and you imagine yourself in Mr. Wright's position, and this officer is behaving as though he's in the middle of an emergency, and you are the focus of his ire. That I think a reasonable person, being on the receiving end of that shout to stop, understands that they've been seized, and that's what's required to determine that it's a level 3 stop.
So the lights being activated before the officer exits the vehicle, that's not enough.
No, I look at that as the precursor to an investigatory stop, a level 2 momentary detention for pointed questioning. Right.
Right.
It could also indicate an intention to forcibly detain someone, but not necessarily.
Right. So it's a 2 at most with the lights on. Right.
Yes.
And what your argument is it changes to a 3 immediately when the officer exits the vehicle and screams stop.
Yes.
That's automatically makes it a level 3 under your argument. There's a lot packed into that question, Mr. DeFonso.
Automatically, I mean, as in every case, it all depends on all of the factors, right? We have the time of day, right? It's after midnight. The area, I mean, it's a totality of the circumstances test. So a lot is packed into the word shout, right? And as I mentioned in my reply brief, these considerations are going to become even more and more nuanced as every case comes with its own video recording. So what might have been just a mere shout, in 1990 is no longer the case.
The question at the hearing was, did you scream stop? And the officer said yes. So that's a scream. But you say facts and circumstances. This is where I'm having a little difficulty with your argument. Temporarily, time-wise, right? It's very close to the assault call, 6 minutes or so, right? And distance, it's very close by, a couple of blocks or so is the testimony. And the description of the defendant with black shorts, no shirt, and a cap, Hispanic male. So you have the description, you have the temporal location, you have the location. So under your facts and circumstances test, Don't you think there's a reasonable argument to be made that it's a level 3 or level 2 at that point?
Yes, I think it was a level 2. At that point, it was, but it can't be more than a level 2.
Even with the screen?
No. I'm saying is that no more than a level 2 is justified because innocuous behavior, the matching description can't rise above a level 2, right? But I think being on the receiving end of that screamed of the shout would, if a reasonable person would understand that they're seized at that point, that there's no more ignoring the officer.
Okay. Would you take us to your second point, which is assuming to the contrary, what's your argument then with the flight?
Well, the argument is that the flight is provoked by the scream that we're talking about, is that, a flight is not automatically, it doesn't automatically create reasonable suspicion. And I think that can be suggested in a lot of the case law, but, the truth is that it's always a totality of the circumstances test, right? And it may create reasonable suspicion or it may not. And it really depends. And so if you have flight that is essentially provoked by an officer who, by what we've already described, and it's not suspicious. And, you can't do a study by trying to, scream, shout at 100 people per night. But I think if you did, a fair number of them would also run. Unless there are any questions.
We're all set. Thank you.
Police in this case operated within what the law gave them. Level 2 allows them to interfere with an individual to the extent necessary to use level 2. So
Does it matter, Mr. Williams, that it's a scream?
no,
Why not?
because there's case law that says that the police can do it. There's prior case law. There's no case law on my opponent's side. The police can turn on their lights. I have a third department case that says that. The police can shout. I have a third department case that says that. And I believe that I have a case from this department that says it as well. I quoted a lot of cases in my department that said that the police were well within their rights to do what they did here. This defendant took off. The officer opened up his car door, was stepping out and shouted, "Stop." This defendant took off immediately. This wasn't a situation where something less than that was going to get the job done or that this somehow made the defendant run. He was taking off because he didn't want a confrontation with the police at all. The police did not draw guns. The police did not cut him off. The police did not lay hands on him. They didn't do anything that would give a reasonable person cause to believe that he was being seized. All they did was say, "Stop." A reasonable person in that circumstance would say, "This officer just wants to talk to me." And I think that that's where the police can operate fairly. And that's what they did in this case. The defendant's flight falls within all the cases that are out there. And the case that I cited in my brief that says flight upon approach of the police gives reasonable suspicion.
With the other facts and circumstances, the matching description, the location, the timing, etc., correct?
Correct. Everything about this case, the judge followed the law and the judge's decision shouldn't be disturbed. We were at level 2 right from jump. There was an anonymous call. The most we can be with an anonymous call is at level 2. But the call was descriptive. It gave a description of the individual. It said exactly what the individual was doing. It gave a location and it said the direction the person was going. Within 6 minutes of that call, these police located an individual fitting the description, 2 blocks from the location, going in the appropriate direction, wearing no shirt, black shorts, and a baseball cap. Reasonably, they executed level 2 on this defendant and asked him to stop. They turned on their lights. He kept walking when the lights were on. He stepped out of the car, said stop. He jetted. From that point on, everything else is level 3. The subsequent command to stop, the get down to the ground, the continued chase, all that was legitimate under level 3. I would submit to this court that these police followed DeVore to a T. Unless there's any questions, I have nothing further.
We're all set. Thank you.
Thank you. This is my first time back here in 20 years.
I was going to say, we hadn't seen each other in a while, but
It's been a long time. I used to argue when this was in the Hall of Justice, and then they moved over here. I haven't been here since 2005. So it's good
thank
to
you,
be back.
counselors. Next case for argument is number 464, People versus Sims.
Good morning, Your Honors. James Hobbs on behalf of Mr. Sims. I'm going to stick with point one in my brief unless you have any questions about point two. The contention there, I think, is pretty straightforward. My position is it's not enough for conviction for robbery in the second degree that a victim or witness fears or just thinks that the defendant might be armed. There must be proof that the defendant is trying to make it look like he's armed. He's trying to give that appearance. My position is that the people lacked proof of that intent. In the case law, we see a lot of indicia of intent in these cases. Oftentimes, there's a threat or a statement to accompany some hidden gun. So the threat can be express or some implied statement suggesting that the person is armed. There's also oftentimes something distinctive, even though the object is hidden, it's distinctive in some way. It's a pointing finger underneath clothes, or it's something in the shape of a gun, right?
Yeah. Why don't you tell us, the sum total of what you think that they were able to show?
Okay.
Okay, because, we've discussed this, we've
Great.
been through your transcript. And, and I'm interested in knowing what you think is the best that they could show us.
Right.
Okay.
We have two witnesses, teenagers, Dylan Lipa and Mr. Narsap, who both testify sort of, not as the most important thing they thought about the incident, but secondhandedly sort of, oh yeah, he had one of his hands in his pants when he came up. The defendant approaches quickly, comes up, says, "What's in your pocket?" Reaches in, grabs the items out of the person's pocket, and then jogs away. And these two witnesses say, "Oh yeah," and also his other hand was underneath his sweatpants, sort of in his pants. They don't describe.
Counselor, you
Yeah.
mean you're, I understand telling us what the record says, but
Mhm.
as I read the record, he had both hands in his pockets. That was the testimony. Question, what was he doing? Answer, oh, he had his hands in his pockets.
Mhm.
Later on, answer, like with his hands in his pockets, indicating both hands in the pockets, in the pants.
That does suggest that. My reading of it, I mean, obviously he had to have the other hand out at some point, one hand to reach into Mr. Lipa's pocket to remove the cash. And
Right, and this is a 16-year-old too, who's
Right.
the victim of this crime.
Yes, my overall reading, and I think he was a couple years older by the time of this testimony. My reading was one hand in the pocket, one hand used to commit the theft. And, but it's possible you could read that to be both hands in his pants, which I think would be less suggestive of a robbery even. I mean, both hands suggest I'm just keeping them there to keep warm or something like that. I'm not holding something.
Mr. Hobbs, following up on Justice Del Conte's questions, here's what my notes reflect was the testimony that I thought was what we needed to focus on, but I'm not excluding other
Okay.
points. Lipa testified, had his hands in his pants. He gestured at trial, Lipa did. The prosecutor put on the record what it looked like
Mhm.
underneath the pocket of his hoodie areas where his hand was.
Mhm.
And then also under his pants a bit is what was said. And then Lipa says, I thought it was a gun.
Yep.
The friend, Narsap, says, had in pants, making it look like they had a gun, just looked like he had a gun.
Mhm.
Why is that not sufficient? Because now you have your client, you quote from Baskerville. And
Yeah.
about, in a way, you're focusing on the conscious acts and what was intended by the defendant.
Mhm.
The court also focuses on what was perceived by the victim. It's both tests. It's not just one or the other.
Right.
Clearly, that's what the court said in Baskerville. So given what I just quoted, why is that not enough to go to a jury to then hear the CJI about what's the language in the CJI? Manifestation of manifested the presence of.
Right.
An object.
What's it?
Manifesting the presence of an object that the victim may perceive as a weapon.
That's exactly what I was going to go with. Thank you.
Glad you're here.
Mr. Hobbs, we don't mean to get you off your arc, but that was great. Thank you.
No.
But in any event, Mr. Hobbs, you get my question. And so why isn't that enough to go to the jury to hear that charge?
Because this act is so ambiguous. It's not even really an act. He's holding there's no testimony that there's any motion, that there's any words, that there's any gesture, any pointing or thrusting. It's just where he had his hand.
The jury is the one that can sort all that out, as long as there's enough there to suggest that perhaps the could be a gun. And the jury can figure out whether they really think that happened. Right?
I mean, on what basis could a jury rationally infer that this was a defendant trying to create the impression that he had a gun, as opposed to just, a mannerism, an affectation, a way of holding his pants up?
But just to follow up on my colleague's questions, approach someone in an alley, run your pockets, got his hand under his shirt, takes money out of the pockets,
Mhm.
Doesn't the surrounding circumstances infer that the client may had a gun underneath his arm or was showing that might be displaying that he might had a gun?
I mean, I think a victim in that situation would be wise to be fearful, right? I think, there's a chance that the person might be armed, but there's always that chance. I mean, they would have been fearful had he had his both arms out. They suggested that this guy's bigger than me. I'm a little kid at that point, right?
And if I'm not mistaken, but you probably know the facts better than I do, I believe the face was concealed from one of the defendants, right?
Both defendants, one defendant had a ski mask. He stood back a ways and was found to be not involved
The
at
other
all.
had the shirt part.
He had it wasn't a mask, but a hood that was drawn in a way to cover up his face. That's correct. I mean, we have case law, tons of case law from the Fourth Amendment context or the DeBoer context in street encounters, where a hand at the waistband doesn't even provide reasonable suspicion that the defendant is armed and about to commit a crime, right? You need something more. This is the Cady and Riddick, which are in the briefs, and there's a number of other cases like that. Without the audible click of a gun or the shape of the gun, the police are not going to be justified to presume that the person is armed. In these street encounters where a person grabs at their waistband or puts their hand underneath their sweatshirt. So if it can't be reasonable suspicion, I don't see how we get, that this is proof beyond a reasonable doubt that this defendant is trying to create the impression that he's armed. And the reason for those cases, I'm sorry, I didn't mean to cut you off. The reason for those cases is that this is ambiguous. It's an action that has many, many explanations and is far too common to show.
They could have done a better job. I mean, if there was some kind of manifestation of a gun, I think the prosecution could have done a way better job than they did.
Mhm.
Okay. But I'm still wondering whether or not there was enough that, the jury could make that determination that there was such a manifestation.
Our position is no. I mean, the testimony he has his hand in his pants. And I thought it was Mr. Lipa even says, no, Mr. Narsap says repeatedly, I didn't see the shape of the gun. I didn't see the print. He just had his hand in his pants. And he says, he even speculates that, well, if there was a gun, maybe he was hiding it further underneath his clothes. So he's actually supplying this guess that he's making. It's not something that he sees that is the shape of a gun. There's a hand in the pants and maybe there's a gun that he's keeping obscured from me or something like that.
Mr. Hobbs, I'm looking back at Baskerville, which you cited a number of times,
Yes.
and it's interesting how the Court of Appeals back in 1983 talks about how the legislature amended the statute to allow for this display of a firearm. And it says there that the apparent justification for differentiating the situations between actually firing a weapon and having it, displaying it, the apparent justification for differentiating the situations is the difficulty of proving when no shot was fired that what appeared to be a weapon was in fact a weapon. And then the court goes on to say we're supposed to construe the penal law according to the fair import of the terms, et cetera. You know what I'm talking about, the case.
Mhm. Yes.
But if we look at that language there, it seems to me that the difference from the Fourth Amendment cases is here the definition of display. And the concept is, I think, intentionally different according to the legislature. So do you agree with that?
I mean, there are some differences. I mean, what the police are concerned with in the Fourth Amendment context, or what we're concerned with, is whether or not there actually is a weapon there. And here we're talking about what the defendant's intent may have been, right?
And what was perceived by the victim.
Right. But there has to be an intent as well. I mean, there's no doubt that there was a fear on behalf of these, or a belief on behalf of these two witnesses that he may have been armed. I don't think there's proof that Mr. Sims was attempting to put that impression in their head.
The briefs have cited a lot of cases. You went through a whole litany of cases displayed, so we'll take a good look at that.
Okay.
Anything further?
Just the one follow-up point is, I want to say that if there was no intent to create the appearance of being armed here, I don't think there's any other evidence of force. And this is not, this is addressed in my sort of point about what you could reduce this to under a legal sufficiency position. But there's some additional case law. There's a case called Juergens out of the Court of Appeals from 2015, which held that a DC statute that includes a sudden or a stealthy seizure, so just a purse snatching, a pickpocketing happening suddenly, wouldn't be included in our robbery statute. It's not enough that you reach into someone's pocket and run away. So there's no other evidence of a use of force or a threat of immediate use of force. So I believe that would have to be reduced down to a form of larceny, particularly petty larceny.
Thank you.
Thank you.
Good morning, Your Honors. Aaron Schwally for the people. I'll endeavor to be concise this morning, and in an effort to do so, I'll plagiarize myself from a few months ago when I wrote this brief, and that there is, to the extent that there's any socially acceptable reason to stick your hands down your pants in public, it strains logic that the ideal or necessary time to do so is while you're simultaneously reaching into a stranger's pocket and removing his wallet. We know what the case law is, and I would just encourage this court to apply that case law to the facts of this case and affirm. Let's
Thank
put
you
those
very
other
much.
questions. I'll rest on that. Thank you, Your Honor.
Thank you. Next case for argument is number 466, where we have both counseled by video, as I see it. Mr. Banaszak, I can see you. Can you hear us okay?
I can, Judge.
And we're waiting for Mr. Valdina, I believe. There we go. Mr. Valdina, good morning, sir. Can you hear us okay?
Yes, I can hear Your Honor, yeah.
We can't hear you just yet. Let's try that again. Just say a couple words for us. We'll see if you're there.
I should be here.
You are. Perfect.
Okay.
And you can hear us okay.
Yes, Your Honor.
Excellent. Mr. Banaszak, the floor is yours. Go ahead, sir.
Thank you, Judge, and may it please the court. The lower court's decision should be reversed because it misconstrued both the plain language and the legislative history of the Domestic Violence Survivors Justice Act. It also ignored basic principles of statutory interpretation and modern, more enlightened understandings of domestic violence and its impact on survivors. I'd like to start with discussing why this court should not defer to the credibility determinations of the trial court. While we all know that that is the general rule in the typical case, this, however, is not the typical case, and it is not so for several reasons. First, the lower court's series of legal errors here suggests that it was inclined from the start to deny Ms. Newkirk's application, and those errors skewed not only its fact-finding, but its overall decision-making. In this regard, at the very beginning of the case, the court not so subtly suggested that it was actually inclined to potentially impose a longer sentence on Ms. Newkirk if she were to proceed with her CPL 447 motion. That led counsel to actually file a motion for recusal that was ultimately denied. Importantly, I think the court's legal errors were not limited solely to its interpretation of the DVSJA provisions. The court also wrongly compared a defendant's testimony in such a case to self-serving hearsay, which is generally unreliable and inadmissible. In that respect, it essentially imposed a credibility discount on Ms. Newkirk by virtue of the fact that she was a defendant. What's,
Okay, counsel, let me focus you a little bit on, let's talk about the time frame. When she claimed she was a victim of domestic violence and when this crime took place. You know, my understanding is that she complained that her stepfather abused her when she was much younger. Was there, and then obviously there's something wrong going on here in this situation. But the court, let's go to the first step. What's the abuse that you're claiming underlies the ability to go back and resentence?
sure, so as this court determined in People v. Wendy B.S., we have to take a full picture approach and consider the totality of somebody's abuse. And here, Ms. Newkirk suffered a lifetime of abuse. She suffered childhood sexual abuse for nearly a decade, almost her entire childhood, sexual abuse that constitutes an A2 level felony. For 2.5 years, she suffered essentially a campaign of coercive control by the decedent. I think perhaps I described the forms of coercive control in the brief, but perhaps the most salient one is the decedent's frequent threats to kill Ms. Newkirk, and that was corroborated by both of Ms. Newkirk's children.
Okay, now we get to the day that all this happened and she shoots the boyfriend, okay? You know, from all accounts, it appears that she was the aggressor from moment one, okay? You know, if that's so, how do we apply the statute to her favor?
Judge, I disagree that she was the aggressor to the extent that she was the first one to become physical, then maybe she is the aggressor. But I think we have to again look at the totality. And that night, the decedent is essentially accosting her verbally. He's calling her names. He's humiliating her. She indicated that he would not leave her alone, and ultimately he essentially cornered her in the mudroom. At that point in time, she fought back, and she did that because she had previously been threatened. She had been shown where the decedent had shown her where her body would be buried. He told her about harming animals, which Dr. Gill testified is often a precursor to harming people. So she had a legitimate fear at that point that she would be harmed. So yes, she did put her hands on the decedent, but at that point in time, and this I think is critical, the decedent put his hands on Ms. Newkirk's neck and choked her. This court has found that strangulation can constitute deadly physical force. And at that point in time, she hit him over the head with a picture frame in order to try to alleviate that threat.
When the court called it self-serving, I think, you know, one way we could look at it is that she had killed the other witness, okay? And there was nobody who could say that anything other than that occurred. But let's look at some of the, the actual acts, you know, he's the one who called 911, worried about her safety. Or that's at least what he said. He called 911 and said, I'm afraid she's going to hurt herself. And I don't think we could dispute that because that's recorded. Unlike some of the stuff that you just explained to me about what she said was going on. How does that fit into the schematic of the statute?
I don't think it changes the result that this court should reach, Judge, because even though the decedent is the one who called 911, he is still the one that had subjected Ms. Newkirk to 2.5 years of psychological abuse. Yes, he is saying that he's telling the 911 operator that Ms. Newkirk is the one that may harm herself, but she's taking that as, from her perspective, as somebody who has been traumatized throughout her life, as potentially him being ready to harm her and simply telling the 911 operator that she's the one that's about to harm herself.
Right, and at some point, I think she admitted to police that she, quote, beat the crap out of him.
She did say that, and that's again, but that was in response to him accosting her and she doing what she needed to do from her perspective in order to alleviate the threat that was coming from him following her around the house and cornering her in that mudroom.
And then lastly, I'll just say that the proof was that 2 of the shots that she fired at him were to his back.
Judge, undoubtedly, Ms. Newkirk pulled the trigger. There's no doubt about that. There's no denying that. And that also is not a disqualifying factor. In all of these cases where somebody is seeking DVSJA relief, they have committed a crime, and often it is a homicide, whether it's manslaughter or murder. So necessarily there was an intentional act. But the DVSJA recognizes that somebody could be both a criminal defendant who has committed a crime, but also a survivor of domestic violence. And what the legislature has asked this court to do is to consider somebody's status as a survivor of domestic violence to determine whether that lifetime of abuse has played a role in the underlying crime. And under these circumstances, as we further, I know the court is familiar with the facts, but as we thoroughly describe in our brief, the trauma that Ms. Newkirk experienced was clearly a significant contributing factor to her actions that night. We know that from the totality of the circumstances that we've been discussing. We know that from Ms. Newkirk's statements when she said she was choked. The decedent said he was going to kill her. She had a legitimate fear for her life. And we also know that based on the expert opinion testimony that was provided by Dr. Gill. I won't go into all of the legal errors that the court made in interpreting the act, because I believe the court has an understanding of those based on its focus on the facts. But I would close with the third prong of the DVSJA. Ms. Newkirk has now served over 12.5 years in prison. She has no prior criminal history. She's in honor housing, which requires a good disciplinary record. There was some testimony of disciplinary infractions early on in Ms. Newkirk's incarceration, but the last one was in 2015, which was more than 10 years ago. She's taken advantage of various programming, including alternatives to violence, as well as domestic violence education. She is somebody who had a clean criminal record again, an employment history, and her prospects for a law-abiding life are good. I think in light of that, and in light of her meeting the first 2 prongs of the DVSJA, she is entitled to the compassionate sentencing relief that the legislature intended be afforded to somebody like her. And so I would ask this court to reverse the lower court's order and to resentence Ms. Newkirk. Thank you.
Thank you, Counselor. Mr. Valdino.
Thank you, Your Honor. Good morning. Of course, we have an individual claiming that she is the victim of domestic violence when she is the one who chased her live-in boyfriend around the dwelling with a shotgun, fired at him multiple times, hit him 3 times, including in the back, while he was literally on the phone with 911. The only physical violence that she claims at the hands of the victim, Hank Davis, is that he choked her. But as the court concluded, if that happened, it happened during the course of the onslaught of violence that she was unleashing on Mr. Davis in self-defense by him. And what we had here is a court that reviewed the submissions before it, heard testimony, discredited substantial parts of that testimony, and then made a determination consistent with the statutory factors. So unless there's a showing that the court abused its discretion or did not credit testimony it should have credited, there's no basis for reversal. And based on that, we ask the court to affirm the order of Supreme Court in this case. And unless there are any further questions, I rest on my brief.
Hearing no questions, Counselor, we're all set. Thank you very much.
Thank you, Your Honors.
Moving next to number 467, People versus Cotto.
Good morning, Your Honors. Paul Skip Lazier on behalf of Monroe County Public Defender for Miguel Cotto. People in this case failed to disclose routine automatic discovery, rendering their certificate of compliance improper, readiness illusory, because the COC was not filed in good faith. They admitted in the COC itself that they had not done it.
To the beginning here, though, what I think the bigger problem was there enough in the motion itself to even get there? Because
yes, there certainly is, Your Honor.
There's certainly nothing in there that even says what this date of the arraignment, how this whole thing started, what time was attributable to the people. I mean, it says a lot about the COCs, but I'm not sure that there's enough in there to get past all.
Okay, Your Honor, in the motion, Mr. Cotto alleged the prosecution shall not be deemed ready for trial for purposes of 3030 unless it filed a proper certificate. If it never filed a proper certificate, all the time is attributable to the people. So we didn't need to talk about.
But that time could be within the 3030 timeframe. If you don't do some suggestion of the math of the dates, that is, you don't go into some suggestion, you don't need a lot. I realize that on the defendant's motion. But if all you do is say is the COC is improper, you would agree that's enough. That's not enough.
No, that is enough.
Just to say the COC is improper.
Yes.
What if it went to trial a week later? See what I mean? There's a disconnect there, Mr. Leisure, as far as I could see it, but I'd like to hear from you.
Okay. Well, that's true. You're right. If it went to trial a week later, we know it didn't. We know that there was still outstanding discovery in June, and the trial did not happen until later. So yes, I suppose technically he didn't state the amount of time, but there was also no subsequent certificate of compliance filed that would have started. So in other words, there was never any legitimate statement of readiness by the people. And he alleged that they have to have good faith. They didn't have good faith because the very certificate itself said we haven't given everything over. He even specifically said that people were not actually ready for trial when they signed their certificate of compliance, and it was invalid. I mean, if this had been 2 years later, would we be having this conversation? I mean, it seems to me that the amount of time that passed and his legitimate statements in the motion is enough. And that's where that goes. So there's no explanation for why the people didn't disclose the things that they admitted that they hadn't disclosed. They didn't disclose them for several months, many of them. There's no request for a special circumstances for a delay. They hadn't even waited long enough for there to be time to get the grand jury minutes or the CVs or the things that were outstanding. Now, I know that this court has said that the limited availability of transcription services can be a reason for grand jury delay, minutes delay to be excused. But the court also said in Baker that the people have to set forth evidence of that. This limited availability of transcriptions, that's in their boilerplate. They put that in every case. There's no individual special circumstances, which is what the statute says. So that's not a reason to excuse the grand jury that was not disclosed until June or after. DNA testing was not completed because they never started it on time. They didn't even ask for Mr. Cotto's buccal swab until July. How can they be ready for trial when none of that has even been asked for? There was no explanation for why they didn't turn over the CVs. The delay in the 911 call and the CAD, how could that be a special circumstance? That was also not disclosed until June. We don't know any reasons for any of this, which the statute plainly says they have to give reasons. That's basically what I have to say about that, except to close with this. It appears in this case that the people treated this as the way they normally treat it, before the statute. They did their, they answered ready right at the beginning of the case because they felt they were ready. They put in now they know they have to put in a certificate of compliance, so they put in the certificate of compliance, and they listed right in the certificate of compliance why it was not filed in good faith, because they had not, in fact, even allowed time for the discovery to occur. With respect to the evidentiary errors, I'm not going to go through what they are, other than to ask the court to pay particular attention to the hearsay of Nurse Bianca, because that was clearly only related to law enforcement. But I do want to talk about harmless error a little bit. There was the only DNA evidence attributable to Mr. Cotto was on a bed sheet. There was no saliva in the mixture where the complainant said she had spit. There was no typing of DNA anywhere else in the house. Yes, there was sperm found in different locations, but I remind the court that 2 teenage boys lived there, and that was their bedroom. There was no male DNA in the rape kit. And so if all of this, if 3 times a week abuse was occurring, you'd think there would be more. Thank you.
Thank you.
Good morning, Amy Wallensack on behalf of the people. Justice Smith, I agree. There's a clear issue to even examining the COC contentions on appeal here, because defendant never set forth any time calculation. And I think more egregiously, there's no evidence in this record that this motion was ever served upon the people. So we were never given a chance to respond to his contentions. The court acknowledged that even in deciding the motion, that it wasn't clear that it was properly filed or served.
But even if it was,
I would submit to the court that there's more than enough in the record here to determine that we filed our COC properly. In the COC itself, I believe there were explanations for the missing items identified defendant in several locations. And also at the court appearance after we filed our COC, I believe it was on February 7th. I could be incorrect on the date. The prosecutor even explained to the court, after explaining I filed my COC, I requested the CV from the sane nurse. She hasn't provided it to me yet, but I will turn it over to defense counsel as soon as I receive it. There were explanations in the record. With respect to the grand jury minutes, I believe this court has squarely resolved this issue in Flowers and I believe Greer from a couple years ago. The lab test, at the time that we filed our COC, we had complied to the extent possible on that one. I believe it's 245-20 sub 1J says that we don't have to turn over the results of the tests or the information related to that until the testing has been completed. The statute necessarily understands that there's an understandable delay in testing, the amount of evidence and potential DNA evidence in this case. With the buccal swab, I believe that this court's recent decision in People v. Radford, which I am lucky to be a bit familiar with as the attorney who argued it in front of, I believe, many of these judges, I think it squarely addresses the buccal swab issue. The defendant is certainly not in our the defendant's not under our control or acting under our direction. So the buccal swab was not in our possession, and we had to exercise reasonable diligence, certainly in obtaining it. But the relief for belatedly obtaining the buccal swab would be under 245-80 as a sanction, which was never sought in this case. I believe this court addressed in Radford that 30-30 relief is not available for items that aren't in our possession when the initial disclosure periods are set forth. And again, with the 911 call and the nurse's CV, the delay was understandable. I believe the prosecutor set forth in the COC under, I believe it's 245-21, I think it's E, but it's in the COC that she had requested it before defendant was even indicted. There was a backlog at the Office of Electronic Communications, or Emergency Communications, excuse me. And she was going to turn it over as soon as she received it. I would also note that in Bay, the Court of Appeals said that one factor to consider is whether or not how much there's outstanding discovery and how much discovery has been turned over. And I think that implicitly recognizes that it's okay if there might be one or two items that are outstanding, as long as the people are showing diligent efforts to comply and have turned over a decent amount of discovery.
The court has said it's a holistic assessment of the Bay factors.
Yes, Justice Kern, I completely agree. And I think looking at this holistically, we turned over, I believe it was 256 pages of documents. There were 37 items, 3 disks, numerous tech photos, and cell phone extraction data. I think looking at this holistically, the fact that there was a delay in turning over one 911 call and the CV did not invalidate the COC. I believe in our motion response to defendant's omnibus motion, both of those items were turned over as of April 13th, not June as defendant claims. And unless the court has any other questions, I'll rely on my brief.
Well said, thank you. Next case for argument is 471 Smith versus Lucevero.
Thank you, Your Honor. I am Charles J. Greenberg, representing Richard Lucevero at the appeals from the finding that he willfully violated a temporary order of protection entered in favor of the respondent, who is Ms. Raven Smith. I did submit a supplemental record on appeal that does contain the temporary order of protection. So my first part of the argument is kind of rendered moot that you could, with the idea that you cannot view it by virtue of a missing document. I had argued that that the existing record described the order, but now that the order is before you, you can just the order itself. So that part of it has been rendered moot. What is not moot is that my client, that the respondent, Ms. Smith, did not present clear and convincing evidence that Mr. Lucevero had violated the order of protection. I mean, there was very little specifics. I mean, I'm reading in the respondent's brief about 50 phone. Yes.
Okay, so my reading of the record indicates that she alleged that there were many phone calls, maybe upwards of 50.
50.
Messages on voicemail, emails, letters, and calls to the police to get them to undertake investigations. I think that's pretty specific, and it seems like, a heavy weight of things that occurred or that's claimed to have occurred on the part of your client.
Yes. Yes, that would be an excellent question. I'm glad that you answered it, because my response would be is that did she present any dates as to, like you said, voicemails? Did she present the voicemails into evidence? Did she present the emails into evidence? Did reports to the police, were they ever into evidence? I mean, she never provided any corroborating evidence that any of this occurred, like the 50 phone calls I'm reading in Mr. Muldoon's responding brief, Your Honor, is that she never tied it all up. It's like, okay, like a voicemail with 5-minute intervals or a 5-minute voicemail. She could have preserved it and presented that as evidence. I mean, it never really went beyond her say-so. And I think, I'm not sure that really rises to the level of clear and convincing evidence, which is what would be required.
It was certainly appeared to be believed by the judge or accepted by the judge as true.
Yes, the judge did give her the credibility.
That's what it appears to me.
Right. But that also, when it comes to the credibility, that it's not also, Your Honors, it's not enough to look solely at the testimony. You also have to look at courtroom demeanor, and of course.
Okay, and is it your argument that goes in your favor? your client's favor?
Well, she really doesn't go, well, I mean, for both of them, I mean, they were both with their outbursts and then screaming.
Okay, I don't remember seeing any instances where the petitioner was asked to leave court or escorted out of court for his misbehavior.
Well,
But I did see that with regard to your client.
yeah, that was correct with my client, but Ms. Smith, Your Honor, does have the burden to prove her case. And if she's coming in with the outburst and screaming, storming out saying she won't be here for Christmas or New Year's, that certainly should be held against her. So, I mean, even though my client's his behavior didn't exactly help him, I agree with that. I mean, the record is quite clear on that. But ultimately, the ultimate burden of proof goes to her, Ms. Smith. And if she's screaming and behaving as she is, then that's certainly, in my view, would undermine her testimony.
Okay.
So,
Okay, thank you, Your Honor.
you.
May it please the court, Gary Muldoon for the children. It's my position as the AFC that the evidence of the father's violation of the order of protection is more than adequate to establish that the father violated the order of protection a number of times.
Even if it wasn't beautifully presented.
Even if it was not beautifully presented. And the testimony in this case spanned a long period of time, including well before and well after the time. I admit that, but there's an extraordinary pattern. 50 times in one day, as the court has pointed out, at 5-minute intervals, including the mother testifying that the father was interfering with computer equipment, including forcing her to get a change of telephone 3 times, including the children being besieged by having harassment of their tablets and having to get new tablets. And part of the problem in this case is that this trial was there's some decision from this court, I think, where it says that trials should not have to be an obstacle course for a judge. And this is a case in which it truly was an obstacle course for Judge Brinkworth. And she held herself together at one point, even apologizing for getting angry. And the father was baiting her constantly. Now, was the mother acting perfectly? No. Both original attorneys for the parents removed themselves from this case. There was the mother was acting up at times, but it was nowhere near the way the father was. And I don't know if it's because of a TBI, which she said that he had. I don't know if there's any verification of that at all. But he was acting in a simply outrageous fashion toward the judge, to the point that at one point the judge did give Parker warnings, and finally at the very end told him to leave the courtroom when she rendered her decision. I think her decision was appropriate, and her telling him to leave was appropriate. The father testified in this case, and his testimony, I think, was incredible. So I would submit that the court was more than justified in the findings, and that there was a sound and substantial basis, or that the weight of the evidence supports the finding. I should note that as an AFC under matter of Michael B., I met with my clients. I met with one of the children on Monday, confirmed with her that this is she's doing okay, and so is the older brother, who's in 7th grade. She's in 5th grade, but doing okay. I frankly had a great deal of difficulty because there's a confidential address order in this case, so it was quite late for me to be in contact with the children, but they are fully in support of the order of protection and the finding that this court made.
All right, thank you, sir. And I think we're up for the next one too.
Yes.
Thank you, Mr. Grimberg. Next case for argument is 472, the matter of Axel S. There's submissions except for Mr. Muldoon, and you're the AFC in this one too, sir?
That is correct, Your Honor. Gary Muldoon for Axel S. Your Honor, the basis of this PPR proceeding is abandonment. The evidence shows that the that for 6 months, the mother had no contact with the infant son in Wayne County. Instead, she was in Tennessee, apparently due to the grandmother's death, and she was trying to obtain title to the grandmother's trailer. That, I submit, is not sufficient grounds whatsoever to have no contact with an infant child from April 5th to October 5th. And that does not defeat the proof that the department introduced to show abandonment. There was not even a phone call during that entire 6-month period. So that is my position on this matter. If I might address matter of Michael B. I've met with the child, who's about 2.5 years old now. She's been living with he has been living with foster parents for all but a couple of weeks of his life and doing well there. They hope to adopt the child, and I would urge affirmance of this matter. Thank you,
sir. Next case for argument is 473. Conway v. Conway.
Good morning.
Morning.
John A. Schupenhauer representing the plaintiff appellant. May it please the court. This matter started out as a simple problem with a domestic relations order that was rejected by it was Equity Trust Company, the plan manager. And the appellant sought to modify the DRO so that the separation agreement and divorce decree could be carried out. And I pointed out the factual support for that, what was contained in the separation agreement, and also what was contained in the decree of divorce. The defendant here, now the decedent, made the other appellee here as the designated beneficiary of the IRA, which is what really has caused the.
Well, what really, Counselor, if I interrupt you, what really problem here is that the deceased ex-husband violated the automatic order, set this whole chain in motion.
Absolutely,
Right.
he did.
Right. And so your position, as I understand it, is that the quadro ought to be amended to reflect what the party's intention was, and that is for your client to experience 1/2 of those two rollover IRAs.
Exactly right. In fact, there was a specific monetary amount mentioned. And that's what really caused the work with the DRO, because Equity Trust said we can't carry out the order. So
He made
we'll modify it.
your position, Seed, made it very difficult because you started speculating in precious metals here.
Absolutely. Made it virtually impossible, because what happened was.
So let me jump to what you're asking for, at least in terms of the remedy here. You're seeking an amended quadro that provides for a payment over to your client of the original amount, $114,000, correct?
Well, actually, by the time of the conversion, it was 115 because her share had increased. But
Right.
yes.
Because the issue that's in front of us relates just to the amended, what you're seeking is the amended quadro. You have some other claims, equitable liens and some other things against the surviving defendant. But you also seek interest or attorney's fees here. Are you entitled to that in the amended quadro?
Well, with respect to interest, I maintain that we are, because of the fact that the.
But I guess where I'm stumbling here is you're asking for the benefit of your bargain. Half of the quadro, which would have been plus or minus market fluctuation. And now you're seeking a quadro that gives you a set appreciation at 9% statutory interest. I mean, aren't you really entitled to, if under your theory, the original quadro amount, 114, plus or minus market market fluctuation?
My position would be, we should be entitled to be where we should have been, had the $115,000 been rolled over into an account of equity. Now, understandably, that's a figure that is impossible to calculate. And that's why we're asking, due to the defendant's conversion and effectively the beneficiary of the IRA's participation in the whole process and resistance to the issuance of a quadro that would reflect the original terms, we're asking for the 9% interest. Perhaps that is a stretch, but we believe that that would be fair and equitable.
The fluctuation could be more or less than that.
True. And essentially what happened was, because of the investment in precious metals, the account took a dive
The actual.
right out of the blocks. And we wouldn't subscribe to that being part of the formula. In reality, I believe that we would be happy with the $115,000 and hope that the court would consider imposing the 9% because of all the circumstances that have taken place, all of the roadblocks, all of the hurdles that we've had to go over. And with respect to the attorney's fees, we believe that we should be entitled to costs and attorney's fees due to our having to be here to argue this point.
Counselor,
Because I'm sorry, Your Honor.
if you want to finish your thought, forgive me for interrupting. I didn't mean to cut you off that badly. So
That's all right. I was just going to interject that it should have been a simple matter of amending the quadro from the get-go. That's all.
So what I'm focused on is if trying to understand the relief that you're seeking specifically. You want to make sure that the daughter is joined so that relief can be granted against her, right? You want to make sure that the quadro is not vacated anymore, whatever the language is. So you want to reinstate the quadro. Am I close so far on those two things?
Yes, you are.
Okay, this is where the rubber hits the road for me. If we were to grant relief, are you asking this court to modify the quadro to make it effective vis-a-vis the current holder of the IRA? I think it's an IRA. What I mean by that is there is a letter in the record from April of 23 from Equity Trust, that's the holder of the IRA, specifying, well, we can't just give you the 114, but we can do this. And I think generally speaking, it is, you got to appoint a broker, the quadro has to a broker to sell the precious metals because we don't do that. And then liquidate it. So, and then once that's done, then we can distribute. Or tell us which precious metals go to whom. And I'm sorry to go on with this long question, but I'm trying to understand the relief that you're seeking. If it's being requested, are you asking this court to pick one of those options of, amending the quadro? Maybe you're not going that far on appeal. Maybe you simply want us to remit for amending the quadro to be done by the trial court. So that's my question. What are you asking us to do with respect to that third prong of your argument having to do with amendment of the quadro?
Our preference would be that this court direct the issuance of a quadro that requires Equity Trust to effectuate the sale of the precious metals so that a cash equivalent to 1/2 of what was converted, i.e. the 115,000, could be placed in a separate rollover IRA for the benefit of the appellant.
So looking at the April 2023 letter, that's option 1 as I see it in that letter. I think essentially, broker's my word. I don't know if that's one of it, but so your request is that it be cash, not precious metals.
Exactly right.
whatever that might be, because there might not be 114 and change in cash. Now, do you want this court, have you asked in your brief? Because you can't ask us something oral argument that's not in your brief. That wouldn't be fair. Have you asked us in your brief to give that specific relief, or do you want us to remit with direction to devise a quadro along those lines? I'm not sure the question's making any sense to you, but it made perfect sense to me.
I think I get the gist of what you're saying, Your Honor. I believe that if not explicitly, we said in our brief implicitly that that's what we want the court to do.
Counsel,
if that's any help.
Let me see if I can approach it from another angle. I understand you presented a proposed amended quadro to the court.
Indeed, I did.
And as I read your brief, you're seeking a direction from us to order the court to execute and enter that proposed quadro with one change. You're seeking one change, as I understand. Substitute out the language with market fluctuation for statutory interest. Is that correct?
Correct.
Okay.
Yeah.
So you would, for lack of a better word, you'd be happy with a direction for the court to enter that quadro with that one change.
I would indeed.
Yes.
Do we know that the money's still, or that the account is still there, the precious metal account?
Yes. Equity Trust has placed a freeze on the funds, and we've sort of kept them apprised that there's an appeal pending. So unless some other event has occurred, they still have it.
We're all set, sir. Thank you.
Thank you very much.
Morning. May it please court, Susan Duke for the respondent, Nicole Lunder. This case, I've heard your honor's questions, but the law is very clear here. You cannot enter a domestic relations order against a plan that isn't mentioned in the divorce. The plaintiff had ample opportunity here to do what she needed to do, to follow the law. At the time she entered that domestic relations order against equity, when she submitted that in 2019, the defendant husband was very much alive. There's no question in my mind that she had the entitlement to bring an action against him. And I think she would have been successful. No doubt. He had transferred money into a different account. It was a simple application that she had to make with that domestic relations order. An order shall cause. Please give me, judge, an amended judgment of divorce, modify the parties' settlement agreement, because although this is an unrelated account, this is where I would like to find my money. She failed to do that. That is a fatal error. You cannot enter a domestic relations order in a way that does not comply.
Counselor, I mean, I'm struggling with this argument, frankly, because it seems to me that Mr. Conway set this whole thing in motion by violating the automatic order, moving the money out of the two Schwab accounts, which he stated in the settlement agreement, half of which belonged to his soon-to-be ex-wife.
Correct.
And then to boot, he moves it to another account where he incurs about $75,000 in commissions right off the top.
Correct.
Without talking to her, consulting with her, or even letting any counsel know. And then she's got to find out where these accounts have been transferred to. And so your position is she's not entitled to an amended quadro or a quadro in the first place by virtue of him violating the automatic orders.
One thing, in terms of the facts, she was aware. It's in the record that she was aware. They discussed this. It doesn't stop the fact that he violated the order. I'm not arguing that point. The point is legally what she needed to do. Again, she could have filed that violation or the order show cause. She would have won that application, but she absolutely must do it because it must follow the terms of the judgment and divorce in the settlement agreement. I've done a number of these cases. This is the way it has to be done. You have to have an amended judgment divorce. Frankly, the court admitted there because I've never had a judge that would sign any kind of domestic relations, or if you put the littlest part in there that's not in the judgment of divorce, court's going to question, is there a new stipulation? Is there an amendment to the judgment of divorce? We cannot do this. He violated, she had a remedy. She started this process in 2019. Defendant died in 2021. So it isn't even an issue where she didn't have the opportunity to do what she needed to do. I'm not saying that the theory that he violated and then she was entitled to something is incorrect, which is why we say she still has a claim, but it's just not against this account. She failed to do what she needed to do under the law to maintain that account. A court can't, even after the death of the party, court can amend a domestic relations order, but not in any way that doesn't comply with the judgment of divorce and that underlying settlement agreement. And this domestic relations order they see doesn't in any way relate to that judgment of divorce, other than he did something he wasn't supposed to. A judgment against the defendant defends the state, that's obvious. But the domestic relations order is not the proper vehicle to do this because she didn't follow the proper procedure.
I'm stuck on something in terms of this argument that you can't do it under the law. I mean, there's an existing quadro that's directed to the holder of the funds, right?
Correct.
That quadro is directed, so we know where the money is. We know how much the ex-wife is entitled to. So the amount hasn't changed. The location hasn't changed. So what is it you're saying can't be done vis-a-vis the quadro? I mean, can't there be a direction in the quadro to liquidate the precious metals?
The location has changed, respectfully, Your Honor. The location is Charles Schwab. Then we would know what the market gains are. There wouldn't be any argument about what the interest is. She had a right to a qualified domestic relations order against that IRA under the judgment of divorce. Could have, as I'm saying, easily obtained the proper procedure to get a domestic relations order against any of his other assets if the court felt like it was needed because there was some kind of violation, some kind of loss. But
so did you object to the quadro when it was sent to equity?
I was not involved in that.
Did anyone on behalf of the decedent?
No, they did not. But as counsel puts in his papers, there should have been an appeal or something done. There was not. There's no one representing the defendant but you cannot appeal a domestic relations order. But what you can do is bring an application to vacate the quadro because the court made an error. You cannot enter the quadro that is not that in a way that does not comply with the terms of the judgment of divorce in that agreement. You just can't, which the court admitted its error and vacated the quadro in the underlying proceeding in this case. That's the issue. The issue is not that she doesn't have some entitlement, that she isn't owed money by the defendant. It's just how she went about it. That was in my opinion, and not just my opinion, but the way the case law says, is a grievous error on her part to not have done the proper application.
Well, let's talk procedurally here for a moment. Would you agree that there's really two defendants in this case, essentially your client in her capacity as the state's fiduciary, as well as your client in her individual capacity?
As a state's fiduciary, certainly, and she's not a part of this divorce proceeding. That's where.
No, I understand, but your client moved to. I mean, the caption in this case, at least at this point, it's Miss Conway versus Mr. Conway. You agree that that's not correct. That needs to be amended and corrected here to effectuate what the court did in terms of substituting your client into this matrimonial action.
It wasn't ever done. That's part of our issue, that she should not have been added party to this action. Certainly in terms of a state, or if they had added the state to this action, which I never did, they just said you're a beneficiary of this account.
Because part of the claim here is that your client was complicit or participated in the conversion and moving the money from Schwab to equity, and she was controlling it. And at certain times, she was the power of attorney who was controlling that account and maybe even making some of the investment decisions.
Respectfully, I don't believe she was involved with the Charles Schwab account at all. Or that
Not the Charles Schwab.
Right. When she was later made beneficiary, correct.
Right.
But there's a lot of issues with their allegations of her being complicit. They use some dates that are absolutely inaccurate, where my client wasn't even involved in the proceeding. The other party didn't have an attorney involved. There was no ability for her to be complicit at the time this transfer was made. But the appellant here, she did have knowledge when that transfer was made. Again, her knowledge doesn't necessarily mean that she's out. She could have made that application still, like I said, by order of show cause. But the problem is the way she approached this. The domestic relations order, we can't amend the case laws I cited to. You can't amend a domestic relations order following the death of the party, or even if a party is living, in a way that's contrary to the judgment of divorce. That's the problem here. Respectfully. Thank you.
Also, thank you. Case for argument is 476 Melissa AC versus Soda Central School District. And counsel is by video. So we're waiting on the video feed.
Your Honor, it looks like he does not have a video feed.
Say again?
It does not look like he has a camera, Your Honor.
Can we hear him? Counselor, can you hear us? We can't see you, Counselor. Can you hear us?
Oh, he's got his.
So what we will do, at least for now, is hold this case for a little bit, and we'll move on to the next case to see if any of the technical issues can be resolved. If not, we'll deem it submitted. Let's move on to the next case. Next case for argument is number 479, Scutella versus Dill. And appellant's counsel is by video.
We hope.
Theoretically. Mr. Morato, can you hear us, sir?
Yes, I can, Your Honor.
Very good. We can hear you too. We're ready for your argument.
Excellent. Good morning. May it please the court. I'm Robert Moranta III on behalf of the appellant, Paula Scutella, in this matter. I was planning on going through a factual background of this case, but instead I'm just going to hit my two main points. The first point is at the summary judgment stage, when the non-moving party is afforded all inferences, favorable inferences, the facts of this case do not lend themselves to summary judgment, quite frankly, in either direction for us or the defendant respondent. We have a situation where the defendant respondent, Mr. Dill, barricaded a public road in the town of Sweden for approximately 30 seconds. He barricaded that road when it was icy and snowy conditions, and he testified that he saw another vehicle traveling towards him and believed that he had enough time to effectuate his 30-second maneuver. I would submit to this court that even the fact that he merely thought he had enough time is evidence that this should certainly go to a jury question rather than being decided at the summary judgment stage, because his thoughts alone cannot be the basis for summary judgment.
So, counsel, let me see if I can sort of frame this from a procedural context. As I understand it, your position here is that the defendant did not meet his burden. Even though the focus from the defendant's motion papers was on what the plaintiff did or didn't do in trying to avoid the accident, the real issue here is the defendant had the obligation at the outset to establish as a matter of law that he was free of negligence.
So our argument would be twofold. Number one, that they failed to reach their burden at the summary judgment stage, but even if they were able to, we've properly rebutted it with by proving and showing that there's issues of material facts that must be submitted to the jury, including the fact that this public road was barricaded for 30 seconds. And when it's barricaded, he was in a 20-foot box truck, and there's no lights on either side of his box truck. So the headlights are going forward and the rear lights are going backwards. And
right.
So
he saw the plaintiff coming up the road, and he decided to do this maneuver crossing the road and had to reposition his truck at least once. And your position, your point is by virtue of those facts, which were undisputed, there's a question of he did not meet his own burden of being free of negligence, no matter what your client might have done.
Correct. Correct, Your Honor. And then for my second point, I distinguish that as common law negligence, but there's actually a statute that speaks directly to the conduct that Mr. Dill performed, and it's Vehicle and Traffic Law 1211, and it states a vehicle shall not back the same unless such movement can be made with safety and without interfering with other traffic. I would argue that the fact that the resulting the accident resulted is evidence that Mr. Dill violated this Vehicle and Traffic Law 1211. And with that, I will rest unless there are any further questions.
Hearing no questions, Mr. Ronto, we're all set, sir. Mr. Hendricks.
Good morning, Your Honors. May it please the court, Justin Hendricks on behalf of the respondent, Dill. I would say first and foremost that we do think we met our prima facie burden, and in no small part because our expert clearly pointed out that regardless of the speed with the plaintiff who admitted that she was speeding, that she would have had enough time to stop, and that negligence, even a question of negligence, such as under the, I'm going to butcher this pronunciation, Store decision, which was this court's decision back in 2023, that's SZTORE, that negligence alone is not the issue, it's proximate cause, even if there is a question of.
But let's frame this. Let's start at the beginning. You've made the motion. And as I read your expert's affidavit in the opinion, it's focused on the conduct of the plaintiff, whether the plaintiff was going too fast or wasn't paying attention or could have brought her vehicle to a complete stop before running into your client's truck. But there's nothing in that affidavit, at least as far as I can see, that your client acted reasonable, entirely free of any negligence in maneuvering across the highway and backing into the driveway. And then, of course, he is silent to as relates to your client's testimony that he had to reposition the truck. He missed it the first time in trying to get across the road. I mean, isn't it your responsibility on the motion to establish as a matter of law that your client is free of negligence?
Absolutely. I must disagree respectfully, Your Honor. Our duty is to show that my client was not a proximate cause of the accident. And our expert said that the plaintiff was the sole proximate cause of the accident. By sheer definition, that means my client wasn't a proximate cause of the accident. That's our entire intention. That
so even if your client was negligent, the plaintiff somehow was more. I mean, you agree with me. Your expert doesn't give an opinion as to your client's freedom of negligence.
Our expert is not part of the analysis of whether or not my client was negligent. No, but our expert is absolutely part of the calculation as to whether or not my client was a proximate cause of the accident, because we established that the plaintiff was the sole proximate cause of the accident. That's what the expert said, and that's what the deposition testimony affirms as well.
No matter how negligent your client may have been.
In essence, yes. If you are not a proximate cause of the accident, your level of negligence ultimately doesn't matter to the analysis of liability.
That sounds like contributory negligence that we eliminated decades ago.
Well, no, but again, sole proximate cause, Your Honor. It's not a question of levels of proximate cause. Certainly, that's a contributory question, a very different scenario, but that's not what our expert
It almost sounds like a last clear chance argument. You know, you got the last chance to avoid the accident, which I don't think is a valid way to look at this case.
Well, there's no argument being made about last clear chance. The argument is that, one, we think the deposition testimony of our client alone establishes reasonableness. There's a question of that, so be it. But the totality of the evidence shows and establishes, and the lower court agreed, that the plaintiff was the sole proximate cause of the accident.
And we're not really sure we get to that question. In light of the fact that you haven't eliminated negligence on behalf of your defendant, do we even look to the plaintiff's action?
I don't think that's how the analysis works.
I think that I've seen it about 1,000 times this way. Okay, you know, like in virtually every case that we discuss summary judgment in a car accident case, you know, so.
Pagels versus Mullen. I don't
Yeah,
mean to
no,
talk over you,
please.
just interjecting.
All right then.
I appreciate your time and your effort, Mr. Hendricks and Dolores. Thank you. Thank you very much. I think we're gonna recall that other case. I may have seen a flash of the video coming up on the screen. There we go. Counselor, can you hear us okay? We're gonna go back now, just for clarity's sake, to 476. We're calling that case again. And we have counselor by video, counsel for the respondent, as I understand it, sir, and we're all here, and can you hear us okay?
I can indeed. Thank you so much, Your Honors, for your patience with my brief technical difficulties.
No, it's fine on this side. Don't worry about it at all. We're all set to hear your argument, and the floor is yours.
I appreciate the time, and I will not take too much of it, with full recognition that we have read and digested the decision in the companion appeal on this matter. But we feel it is necessary to highlight a few important things here on this particular appeal. First and foremost, there's a factual difference in the two plaintiffs between the companion matter and the present one before this court. Simply put, this particular plaintiff alleges less. She does not make the same allegations as the plaintiff in the prior matter decided by this appellate division. In fact, all that she alleges is that another child on a bus exposed himself to her. That is number one, and I think that needs to factor into whatever difference in decision, if any, there is on this matter. Number two, in light of this court's and similar courts' prior decisions on the topic of notice for a school district, the decision in the companion matter, in our view, seems to enlarge the area of liability for a school district in a manner specifically contemplated by prior courts, which shouldn't be done. Essentially, a school district is being penalized here for taking prompt action and adhering to the federal FERPA law. And also, plaintiff is being rewarded for not doing their due diligence in discovery and obtaining an appropriate order if they believe there was some question in this child's records that they're alleging committed some sort of misconduct that would have given the district notice. We cannot come forward on our own and put that evidence up. I have several cases on my docket right now where opposing counsel has to file an order to show cause to obtain those records and have them released. Oftentimes, we don't have sufficient grounds or reasonable grounds to even oppose that, but such an order needs to come down before we can provide that evidence to any sort of plaintiff in these matters. And the prior decision, not more than implicitly, puts the onus on us, on the district, to come forward with some kind of evidence to show that essentially a child within our care has never committed sexual misconduct before. This is, to me, a new standard that is not in the prior case law. It's an enlarged area of liability, and it's exactly the type of enlarging of an area of liability warned against by the courts in this sort of subject area before. If we look at matters where notices have been at issue, as cited in my appeal, just off the cuff, for example, DSCC versus Ithaca City School District, or Lisa P versus Attica Central School District. You have situations where no notice was found in circumstances that are far more intricate, where you have teachers known to be sleeping in the same room with a child, and notice was not found. Here, notice.
Counselor, let me just interrupt you real quick with one quick question from me.
Of course.
Do you think it's a fair reading of the companion case decision that all our court did was decide that on that particular record, which is the same as we have here, that the moving defendants had failed to carry their burden to establish judgment as a matter of law? In other words, you're not at trial. You have the sole burden to establish summary judgment as a matter of law. And as I recall, all our court said was, on this record, you didn't carry this burden based on the testimony submitted. But that doesn't mean the plaintiff wins or we enlarge liability. Do you agree with that reading of the decision?
Yes and no. I would say that, yes, that is, of course, what, I mean, this was a decision on a motion for summary judgment, and that was the ultimate holding of this court. However, my particular argument regarding the enlargement of liability is the prior decision creates precedent that if a plaintiff comes forward with sufficiently vague allegations and does not do their own discovery work, then there will be a question of material fact to proceed to trial in almost every circumstance.
But again, you're looking, Counselor, respectfully, I think you're looking at the burden that would be on the plaintiff. As I recall our decision, we didn't get there. We simply found that the school district on the testimony submitted did not carry the burden. We never got to the issue of whether plaintiff raised a trial question of fact. Do you think that is a fair reading of our decision in that case?
I do. I do think that is a fair reading of the decision, and our dispute is more that in this particular case, even in light of that decision, in this particular case, considering the standard in that decision, we have finding that we have not met our burden would essentially be tantamount to plaintiff always meeting their burden on sufficiently vague allegations.
I think we have that argument, Counselor. Anything further?
Nope, nothing further from me. Thank you so much for the time.
You're very welcome. Thank you. Next case, I believe the last case on the calendar for argument is Klim versus Supreme Court, number 480. Justice Smith is recused, and we have respondents counsel by video, as I understand it. Let's see, Counselor, Mr. Morales, can you hear us okay, sir?
Your Honor, I can hear you perfectly. I can't, and I hope you can see me.
We can see you and we can hear you, so we're all set. We're going to let Ms. Korn make her argument on behalf of the appellant.
Okay,
Thank you. Good morning, Your Honors. I'm Lindy Korn. I'm here with my co-counsel, Anna Marie Richmond, and my client, Rebecca Klim.
We typically have clients sit in the audience, Ms. Korn. Would that be okay with you?
Yes, that would be
This
fine.
is sort of for
like
lawyers
this?
what we typically do.
Thank you, Your
It's
Honor.
just the way we do things.
Thank you.
Thank you.
Your Honors, the executive law, section 292.5, was amended in 2021. And the purpose of that amendment was to remind the courts and everyone that the legislature statutorily has created an amendment so that judges' staffs would not have to become sex slaves, as Rebecca Klim did to Judge Rosenbaum.
Ms. Korn, I'm going to interrupt you right out of the box here,
Yes.
just so I cover what I think is a procedural issue. And so I don't want to get you off your argument.
Sure.
But it looks to me like in the briefs, the parties agree that this is a motion to dismiss as opposed to for summary judgment. Do I have that correct?
You do have that correct, Your
And
Honor.
you probably know why I'm asking the question. The court made some reference, at least in one of its paragraphs towards the end, about summary judgment. But as I read the respondent's brief, it looks like everybody's looking at the standard of review under 3211A7. Right, close?
That is my understanding, Your Honor.
Okay, and the court never converted it to summary judgment with notice, etc.
No, they did not.
I looked at the record. I didn't find it. I wasn't as concerned. So, okay, I just want to get the right context.
Yes, Your Honor.
All set. Thank you.
And we are here because we believe the decision below should be reversed. Indeed, the amendment itself, which is in the record as Exhibit A, states that the sexual harassment policy applies to all state employees, and there's no loophole for staff of the legislature, the executive, or the judicial branch, and specifically says that personal appointees of a judge are covered. This is important because the linchpin of the state's anti-discrimination policies and the sexual harassment policy in particular depends upon the state actually following its own policy. And here, the Unified Court System's policy was a cruel hoax for Rebecca Klim. How do we know this? We know this because she tried to complain. And that's an essential element of any sexual harassment policy. She tried to complain because she was having to perform fellatio on the judge about 80 times. She complained about sexual harassment and the workplace because of demeaning comments and touchings and having to attend judges' medical appointments. She complained because there's an alleged rape in this case by Judge Rosenbaum, and no one heard her complaints. No one such as the human resource officer, Marge Allen, who is now deceased but was the human resource official. Rebecca Klim went to the human resource official and complained. And Marge Allen said to her, "If you're here to complain about Judge Rosenbaum, I'm going to have to fire you," which also indicates Marge Allen thought she was a state employee if she had the right to fire her. Judge Taddeo, Rebecca Klim went to Judge Taddeo and begged for some help. And Judge Taddeo essentially said, "There's nothing I can do." Rebecca Klim then went to the Inspector General for Bias Matters. And this was pursuant to this illusory policy of the Unified Court System. And indeed, their response ultimately was that they lost 2 of her complaints. One in 2007 and one, I believe, in 2017 or 18. In essence, the sexual harassment policy, which the Unified Court System says protects all state employees, was absolutely ineffective, illusory, and left Rebecca Klim to be a victim of sexual harassment, sexual abuse, rape, and it caused her harm to her health significantly.
And is that because they claimed that she wasn't an employee of either the Unified Court System or OCA or the state of New York?
I don't have the answer to that exactly, because if the policy was in effect, the human rights law has been clear, and it's broadly to be interpreted. And there's statutory authority that says personal appointees are employees.
So your first point is that it doesn't matter, she's covered.
Yes.
And the second point is what? That she is an employee of one of those entities.
Yes, she is an employee and was an employee of the Unified Court System. So the policy should have been effective for her or anyone. And that's one of the reasons this case is so important. It's actually about Rebecca Klim and any other person who is a personal appointee of a legislature, the executive branch, or the judiciary. I'd like to point out, though, that there's a case, the Gallagher decision, which is in our reply brief. It was not mentioned by my opposing counsel. And that was a Northern District of New York case that involved sexual harassment involving a secretary and a law clerk and the judge. And in that case, it held there is no dispute that personal appointees to judges are entitled to the same rights enumerated in the Unified Court System's sexual harassment policy. Additionally, we submitted an addendum from, there was a deposition in that case of someone named Ronald Youngkins, who was identified in the deposition as the chief operating officer of the Unified Court System. And in his deposition, in the Gallagher case, he testified that the Unified Court System's 2008 sexual harassment policy applied to both judges and to personal appointees. His deposition was March 5th, 2021. The Gallagher case was decided on March 7th, 2024. And the oral arguments in the case below was about a month later. And so I'm directing this court's attention to that case. Additionally, there's a case that's talked about, it's the Bland decision, which was from the Eastern District of New York in 2003. And there's a quote in that case, which we rely on, that states, if the Office of Court Administration failed to implement sexual harassment training and awareness programs, or failed to adequately create avenues for complaints, it could be held liable in the same manner as an employer for a coworker or third-party harassment. The Office of Court Administration's liability does not result from an agency relationship, but rather from its failure to adequately perform the administrative functions for all court personnel. There was a total failure in this case to have the Unified Court System's sexual harassment policy protect our client, Rebecca Klim, and this really puts every state employee at risk if there is no policy, and this should never have happened.
Ms. Moore, may I ask a question?
Yes.
I believe you're saying that that the employee, and please, I'm putting words in your mouth, please correct me if I'm wrong, that the employer relationship exists because your client was issued a Unified Court System badge, had to abide by Unified Court System policies, was given a training procedure manual subject to their time and attendance issues. So that would like encompass that she was an employee of the Unified Court System, and something like this couldn't be decided on papers. It makes it more of a question of fact.
Yes, all of what you said is true. However, I'm really saying that statutorily, the human rights law 292 subsection 5 encompasses personal appointees of judges. And under that statute itself, common law doesn't trump a statutory definition of employer, and 292.5 is exactly that.
So let's say hypothetically, if someone interpreted that law a little differently, you still would say
yes
that there's an employer-employee relationship based on what we both just talked about. Right?
Yes, Your Honor. I also would say that although Rebecca Klim served at the pleasure of Judge Rosenbaum, she should never have had to serve for the pleasure of Judge Rosenbaum. I have nothing further.
Thank you, counsel. Mr. Morales, all set for your argument, sir.
Thank you, Your Honor. Good
I
Good
can hear-
morning.
You're a little,
Good
you need
morning.
to get, Counselor, you'll need to get close to the microphone for us. We're having some trouble with the volume. Thank you.
Okay, I'm going to put this microphone right next to me. Can you hear me now?
Better.
Much better. Thank you very much.
Excellent. May it please the court, Your Honor, Pedro Morales from the Office of Court Administration's Counsel's Office. We represent defendant respondents in this matter. The only issue, Your Honor, on this appeal is the issue of control. In order to impose liability on the defendant respondents for employment discrimination under the human rights law, there must be control, meaning the respondents.
Counsel, let me interrupt you there. I think I understand your argument. I think your position is under the judiciary law, the judge has absolute control over the secretary. That's your position. Is that right?
That's exclusive control. That's right, Your Honor.
All right. So if the secretary posted something offensive on the state computer, only the judge could discipline that secretary?
Yeah, essentially, the way it would work is if she placed something offensive on the court computer and OCA, UCS became aware of it, we would report that to the judge. We could not take.
The judge could say, I don't find that offensive, that's fine. It's not a problem. If it's not a problem with me, it's not a problem with you. That's your position?
That's right.
What if the
judge could say that, yeah.
Yeah, all right, got it. What if the secretary had assaulted someone in the hallway in the courthouse?
Same.
OCA couldn't do anything about that.
No, well, the point is that the employee, that clerk would be still the employee of the judge, but we could take steps to have that person removed from the court system or the courthouse, the same way we could do it with a court user if they also act out of control.
So you in that respect, you could interfere with the judge's control over the employee. And if the judge says, I don't have a problem with that assault, I want my secretary to come to work tomorrow, you could still prevent the secretary from coming into the courthouse.
Well, at that point, Your Honor, we're talking about someone coming into court system property. The chief administrative judge is obligated to provide for the security of all court users and court personnel, and could bar that person from entering the courthouse.
One last hypothetical. If someone in court administration found out that a judge was trying to elicit sexual favors or was receiving sexual favors in chambers, the Office of Court Administration would have no ability to stop the judge from doing that or control that because
Right. What we could do is the following, Your Honor, and it's what we did in this case. We can conduct an investigation. And even if we haven't completed the investigation, we would immediately refer to the CJC for action. The CJC is the ultimate disciplining authority for our judicial personnel. The court system cannot discipline that judge.
No, I'm not saying discipline the judge, but what I'm trying to understand here, and I apologize for these hypotheticals, but the way I read your brief, that the Office of Court Administration, because it's not the employer, has the discretion to investigate or take action. It doesn't have any responsibility as an employer would to protect the secretary. Is that your position?
Well, not as the employer. As the court system, we would have an obligation to report this matter to the CJC and to any other authority, including the district attorney, if we felt there was some criminal conduct being engaged in. But we could not act directly against the judge, and that would be the extent of it. To the extent that the employee is being subjected to sexual harassment or any kind of improper conduct, our options are somewhat limited. We would, as I pointed out, we would report it to the relevant authorities. We could bar people from coming into the building to the extent that would help alleviate the situation, but we could not directly address that situation.
Now, counsel, I heard Ms. Corrin tell this court that there's a statute, Executive Law, Section 290 and thereafter, that is that makes the court's protection available to everybody. That it was your job to protect a secretary, a law clerk, a personal appointee of a judge from, actions against them. Okay, and is she wrong?
Well, I think my understanding from the argument of opposing counsel is she was referring to the sexual harassment policy itself, and to the extent that it applies to all personnel that are in the courthouse or any kind of court facility, and that is true. Our sexual harassment policy is not limited just to our employees. It's to a court user, anybody who takes any is in the courthouse for any purpose. Now, but the mere fact that a court user, for example, may lodge a complaint of sexual harassment against a judge because of whatever interaction may have occurred in the courthouse or in the court hallways, does not make that court user an employee of the court system. So I think that argument by opposing counsel is stretching it a bit too far. Now, with respect to
Ms. Morales, I hate to interrupt, but I know you're familiar with Griffin versus Silva's, a Court of Appeals decision interpreting that statute, and it says there's relevant factors like the selection of the employee, payment of salary or wages, power of dismissal, and power to control that employee's conduct.
Correct.
And if you look at that, OCA or Unified Court System would have the power of dismissal would have the power to control the employee's conduct, wouldn't you say?
There's the Unified Court System, the Office of Court Administration, however you want to term the court system itself, does not have the power to appoint or dismiss a personal appointee of a Supreme Court justice. And that's the situation we're faced with here, which implicates the court system's obligation with respect to any actions it took or did not take in connection with investigating any complaint that plaintiff may or may not have made. Because
but that's what I'm going to go back to Judge DeConte's hypothetical. Let's say hypothetically, a judge appointed employee does something that's, let's say, heinous or criminal.
Right.
Office of Court Administration has no teeth or have no authority to remove that person, even if the judge wants that person to stay.
When you say, I take it when you say remove that person, you mean remove that person from the judge's courtroom or chambers. Well, what we can do is we can prevent that employee from coming into the courthouse. That is the extent of our power, but we could not address that situation directly. It would have to be addressed through complaints made to the CJC and any other entities like the District Attorney's Office. But with respect to, aside from separating the two in the manner we just described, there's not much more we could do. We couldn't address the actual conduct itself in terms of holding the judge responsible for any conduct that he may or may not have engaged in. Well, we could take preventive measures, but the mere fact that we can take those prophylactic protective measures does not mean that the personal appointee is an employee of the court system. We can do that with a court user. We can prevent people from coming in to a courthouse. It doesn't, the mere fact that we have that authority doesn't render the subject of that power an employee of the court system.
So if faced with complaints, from a secretary that says that, over years, okay, because we understand there were several complaints, that there was some sexual misconduct going on, you couldn't do anything about that? Or you didn't do anything about it, let's put it that way. My understanding of the record is that there was nothing done about that.
Well, our position is we didn't hear of those complaints. Had we received the complaints, we would have conducted an investigation and taken appropriate actions with respect to the parties in question. And with respect to the parties in question, we're talking about a Supreme Court judge and a personal appointee to that Supreme Court judge. So with respect to the Supreme Court judge, we can make a referral to the CJC for it to take additional actions with respect to investigating and, if necessary, disciplining. With respect to the employee, we could keep her from coming into the courthouse and separate them from the judge. But that's about the extent of it. And the mere fact that we can do that does not mean that the personal appointee suddenly becomes an employee of the court system. We have an obligation to make sure that our courthouses are safe and secure places. And the mere fact that we can have exercise some authority with respect to whomever walks through those courthouses to achieve that goal does not render the recipient of that action an employee or an agent of the court system for the purposes, and keep in mind, for the purposes of the human rights law. What we're talking about here is holding the court system and the related entities who are named as defendants liable under the human rights law for employment discrimination. And according to the precedent set by this court in GTE Corp, there's a requirement that in order to establish that employer-employee relationship, that the purported employer, in this case, the defendants, exercise control over the work performance of the complainant, in this case, the personal appointee, Rebecca Clem. And based on her relationship as a personal appointee to a judge, the court system has virtually little control over her work performance and has no control over how she...
Mr. Morales, just so I cover these points as part of your argument, it's sort of mundane, but from my perspective, I have to ask you anyways. Do you agree that the context here, despite what was in the Supreme Court's decision, that we're in motion to dismiss territory, 3211A7, correct?
Your Honor, I made it clear in our motion papers that we were taking advantage of the option of putting facts in the record in support of our position to show that there is no employer-employee relationship, which meant that we
Time
put
out,
in.
time out. Mr. Morales, I've read your paper. So you cite 3211A7 and C. You don't cite the 3212. We could only get into 3212 if the court gave notice that it was converting it to 3212, and the court never did so. Am I right on the record?
You're correct. I did not see that. No.
Okay, so we're in the motion to dismiss context. You're saying because you put in evidence, as you're permitted to do, it's not, the analysis is not, does the plaintiff state a cause of action, but you're saying based on the evidence you presented to affidavit, whatever, and based on judiciary law, section 36, on those two bases, the facts you put in, the evidentiary facts you put in, and 36 of the judiciary law, that is where you say that demonstrates that the plaintiff does not have a cause of action. I know it sounds mundane, but just structuring our writing, I need to make sure I have the procedure correct. Am I correct or no?
You are correct, Your Honor.
Okay, I'm sorry, I talked over you again.
Yes, yes.
Thank you very much.
You are correct.
Thank you. Anything further, Mr. Morales?
No, Your Honor, and I have no further argument.
All right, thank you, counsel.
Thank you.